Dear friends, today we'll discuss another very interesting case law which took place between Abhishek Singh versus Huhtamaki PPL Limited and others. In this matter, the Honorable Supreme Court has held that CIRP withdrawal application under Section 12A of IBC cannot be kept pending for constitution of CoC. CIRP Regulation 30A provides a complete mechanism for withdrawal applications being entertained before constitution of CoC and no requirement to hear any other concerned parties except OC, FC, CD and IRP. Let us note facts of the case. The operational creditor had filed a petition under Section 9 of IBC against CD, which was admitted by the NCLT. However, 2 days after the admission, a settlement was reached between the parties and the total amount was paid to the OC. The IRP then sought to withdraw CIRP against the CD under Regulation 30A of CIRP regulations. However, the NCLT rejected the settlement application and fixed the matter for disposal of the application, though under Regulation 30A of IBBI regulations, but after hearing out all the stakeholders. After this order, the IRP constituted the CoC and the applicant filed an SLP before Honorable Supreme Court of India. Honorable Supreme Court, after hearing the matter, laid down that Rule 11 of the National Company Law Tribunal Rules 2016 empowers the NCLT to pass appropriate orders for meeting the ends of justice or to prevent abuse of the process of the tribunal. The application for withdrawal was filed on the 10th day and the NCLT should have immediately taken a step on the application. As the parties settled the dispute even before the CoC was constituted, the application should have been allowed then and there instead of waiting for the other for the other creditors to intervene and allowing the RP to proceed further. With regard to the claims of other parties, the Honorable Supreme Court laid down that other creditors would have their own right to avail such legal remedies as may be available to them under the law with respect to their claims. The rights of the creditors for their respective claims do not whittle down or adversely affected if the settlement with the OC in the present case is accepted and the proceedings allowed to be withdrawn. The Supreme Court further observed that NCLT made an error in holding that Regulation 30A would have no binding effect regarding the withdrawal applications admitted under Section 7, 9 or 10 of IBC before the CoC had been constituted. The Supreme Court further observed that Section 12A of IBC permits withdrawal of admitted applications even before the CoC has been constituted, and the IBBI substituted Regulation 30A to deal with the procedure for disposal of withdrawal applications under Section 12A. The substituted Regulation 30A allows for withdrawal applications to be entertained before the constitution of the CoC and does not conflict with Section 12A. The sum and substance, we may say, of the case law is that though Section 12A of the IBC says that the application filed under Section 7, 9 or 10 of the Code could be withdrawn with the approval of 90% of voting share of CoC, the Honorable Supreme Court has in effect laid down that the Regulation 30A provides for withdrawal even before constitution of CoC. Hence, an application can be withdrawn under Regulation 30A without waiting for constitution of CoC and without waiting for other creditors to be heard. Thank you so much for watching. Have a nice day. Thank you.